Good evening, everybody, and welcome to the Atwater's Jameson and Hill Planning and Construction Seminar. I am Salvatore Amico, an associate and the head of the planning department at Atwater's Jameson Hill. I specialise in planning law and have done so for more than 7 years now, covering the wide spectrum of the Town and Country Planning Act, including Section 106, seal work, planning applications, judicial review, and as well as offering advice on the interpretation of case law and the Town and Country Planning Act itself. Atwater's Jameson Hill is a multidisciplinary law firm specialising in areas across the wide spectrum of both private and commercial law, offering services to our business clients such as commercial property, commercial advice and company commercial advice. We also offer advice to our private clients, including wills, trust and probate and family. Included within our offering are medical negligence, dispute resolution, and as you'll learn a little bit more this evening, town and country planning and construction law. When Charlotte and I first had the idea of putting this seminar together, Charlotte was a bit more optimistic than I was, and I'm absolutely overwhelmed with the, with the response that we've had this evening. I'm grateful for all of you attending. Some of you have come from quite some distance, so thank you for supporting the event and coming today. Joining us today, we have our friends at 39 Essex Chambers. To my right here, we have Daniel Stedman-Jones, who is a planning barrister. Daniel will take us through recent developments in housing and covering particularly the recent developments concerning paragraphs 14 and 49 of the National Planning Policy Framework. Following on from Daniel, we have Rebecca Drake, who is a construction barrister, and Rebecca will take us through construction insurance, including a whiz through the Insurance Act 2015. And finally, but by no means last but by no means least, we have Charlotte Wolven-Brown, who is a construction lawyer within our firm, and Charlotte will be taking us through the adjudication process and how that can be used if any disputes arise during the construction process. Okay, so let's get started. Planning, exciting. Probably not two words that go you hear very often in one phrase. I don't know, there might be 40 people in here that do think that's the case, and I'm sure we all do, or I might be on my own on that front, but nevertheless I think it is true. It's an exciting and interesting time for all those that are involved in the planning profession and all those that are involved in development. With the recent raft of changes, planning is high up in the political agenda and it is high up in the media. It is impacting on the way we work within the profession moving forward and clearly the landscape within which we work. Two recent matters that have particularly caught the attention of the planning world are both the Neighbourhood Planning Act 2017 and the Housing White Paper. Daniel Stedman-Jones will take us more particularly through some elements of the Housing White Paper, but the area that I'm going to be concentrating on this evening is the Neighbourhood Planning Act 2017. The Neighbourhood Planning Act 2017 only received royal assent in April 2017, so we've been going now for just nearly 2 months. The Neighbourhood Planning Act brings into force wide-ranging changes in the areas listed, which include neighbourhood planning, local development documents, compulsory purchase and planning conditions. The area that I particularly want to hone in on today, because I believe that it's an area that's of interest to me as a planning lawyer and of course the audience, are the changes that cover planning conditions. The increasing prevalence of pre-commencement conditions has, as we're all aware, whether there are developers in the room or those advising developers in the room, be it planning consultants, property specialists or architects, has always been a thorn in the side of developers. And of course we are talking about those conditions that require something to be done before we're even allowed to put a spade in the ground and get work going ahead. What is the government hoping to achieve? Well, we're looking at the time lag between planning permissions being granted and work starting on site. In the recent statement issued by the government was concerned about the number of unnecessary or otherwise unacceptable conditions attached to permissions. It is therefore vital to ensure that conditions are only imposed where they meet the tests that are currently set out in the National Policy Framework. I don't need to remind you of the 6 tests that are set out in paragraph 206 of the MPPF, but in order to meet the relevant conditions for a valid condition, a condition must be necessary, relevant to planning and to the development permitted, enforceable, precise and reasonable in all other respects. The Neighbourhood Planning Act amends the Town and Country Planning Act to allow increased regulation in relation to particularly prescribed conditions which are prevented from being imposed in any circumstances, prescribed conditions only able to be imposed in prescribed circumstances, and preventing conditions at all being imposed in specific circumstances. The powers are far-reaching and the regulations are still necessary to make the development acceptable in planning terms, which are the 6 tests set out in paragraph 206 of the MPPF, which I've just set out. Interestingly, the criteria replicates those tests of validity which were previously in policy documents, paragraph 206, but are now set out in statute for the first time. This is a move from policy to legislation, which we saw most recently in relation to planning obligations in 2010. And as far as certainty and those within the professions are concerned, it's a certainty that is welcomed. So the regulations will set out circumstances under which pre-commencement conditions may be imposed without an applicant's consent, and conditions that are prohibited. This is the boring legal bit, which I won't take us through because you'll take the slides away from you. But essentially, these are the sections that are amended in the Town and Country Planning Act 1990, which require the agreement of the applicant to pre-commencement conditions on full planning permissions, and then allows regulations to be made that will set out when permission may be granted, subject to pre-commencement conditions. However, I think the nitty-gritty of it is that the indicative draft regulations are worded such that applicants' written approval would always be required, albeit that in certain circumstances, refusal to give approval would lead to refusal of planning permission. So, the proposed procedure, how would it all work? The indicative draft regulations which are being circulated at the moment are that the LPA will write to the applicant, giving notice of the intention to impose the pre-commencement condition. The applicant is then given 10 days to comment. If you don't respond, the local authority will simply impose the pre-commencement condition. Longer than 10 days can be agreed between the applicant and the LPA. And the LPA are at liberty to decide at which point during the determination process it seeks the applicant's agreement to the pre-commencement conditions. So, I think probably some of you in the room are probably asking, what happens if the applicant does not agree to the imposition of the pre-commencement condition? The options, there are 3, and then I'll move on to a 4th. We would look at changing the condition in question, allowing the developer to comply with it, but after the development is underway, so effectively it isn't a pre-commencement condition, or remove the condition with the agreement of the local authority. Essentially, however, the local authority can refuse if it considers that the pre-commencement condition is necessary to make the development acceptable. That is then a call on the part of the local authority to be able to then, to believe that they're able to justify that on appeal. And it is essentially for the LPA and the applicant to consider if the pre-commencement condition is truly essential and would ultimately an inspector agree. Any regulations that will be put in place must ensure that those tests of validly imposed condition are not undermined. The Neighbourhood Planning Act does produce solutions, I put solutions in inverted commas, providing that the pre-commencement condition must be agreed with the applicant before it is imposed. It does, of course, give the applicant the opportunity to mould draft permissions, which of course allows them to shape the permission from a commercial perspective. However, it is heavily reliant on the extensive discussion and negotiation between the applicant and the local planning authority before permission can be granted. My concern is that developers or the individuals acting for developers may end up feeling forced to accept proposed pre-commencement conditions to avoid refusal of the application if the planning authority disagree with the developer's view, i.e. we can't agree on this, let's just accept it as a pre-commencement condition, it gets us our planning permission and we can just plough ahead. The provision is likely to result in tactical negotiations between the local authority and the applicant. And, of course, planning authorities may draft de minimis carve-outs allowing very minor works that would constitute a material operation. What that means is it allows the developer to start but not do very much until the condition then has to be met. Has to be discharged, apologies, and that ultimately doesn't really achieve the government's aim of trying to reduce the time lag between the date of the planning permission and getting work underway. There are prohibitions on the imposition of the following categories of conditions, and this is a list of conditions that can't be imposed, and those are those that require the development to be completed in its entirety, positively worded conditions which require the applicant to pay money or provide a form of consideration, disproportionate financial burden, that is, impacting on the deliverability of a development, and conditions requiring land to be given up. So when might all of this happen? Section 14 is not yet in force. We do of course already have royal assent of the Neighbourhood Planning Act, but Section 14 does not have a commencement order yet. And at present there's no power to make regulations controlling the use of conditions. So we're still waiting, the regulations are being drafted and we are still waiting for all of this to come through. The Conservatives have of course won the general election. That might be a whole debate for another day, which I'm not going to start here today. And of course, the intentions of Gavin Barwell have been made clear in the media. So I think it's reasonable to conclude that the new measures are likely to be enforced by the end of the year. In my view, I think it involves a bit of a wait-and-see approach if these provisions have the intended effect that the government desire. Of course, the detail of the regulation is essential. When we see the final set of regulations, that how all of this works will heavily depend on that. But of course, the entry into statutes of the test of a valid condition is desirable in terms of clarity and robustness. And it does, of course, mean that changes on the pre-commencement conditions means that developers will need good professional input. That includes advice on and negotiate conditions precedent, if it is, of course, tactically advisable to accept the condition and plough on with the development, or if the view is that chances on appeal may be quite good and risk appeal. But nevertheless, it's going to require adopting a practical approach in any given scenario.